Thank you all for getting up early on a Friday after the banquet last night and all the fun that was had. So thanks for being here. I'm really honored to have with me representing well over 30 years of experience in the IP and life sciences transactions, both Art Cohen from DLA and Connie Mateo, who's Assistant GC at Pfizer. And so we've had the good fortune of kicking this around and preparing for this panel for some time, and I'm looking forward to what we hope is a lively and engaging panel. We will certainly be asking you to participate rather than us just pontificate. So any participation in our presentation is most welcome. The goal here really is to keep you off your phones, right? If we can keep you off your phones, for 45 minutes, we will have done our job. So we're here to talk to you today about mitigating risk in life sciences, licensing transactions, and one of the things that is at the heart of this panel is this manual here, which is, I think, now available or shortly to soon be available on the CPR website, and there are limited, highly exclusive printed copies available for distribution today. So that will be an incentive as we go forward. So we wanted to talk a little bit about the history of how this project and the content of this manual came together, because it involved a lot of people, a lot of input from a lot of really highly skilled and trained individuals. And so with that, Connie, I'll turn it over to you. I was a relatively new add to or late addition to the task force, but you as a co-chair can speak more about the history of the manual itself.
Sure. So this is really David Colvin's brainchild, and of course, he and Alan had the brilliant idea of initially putting together a deck, and then Alan realized that the deck could benefit from the input of transactional lawyers, and he put together a panel consisting of Art and two other other transactional lawyers, and we initially gave a presentation on this topic of mitigating risk in life sciences transactions in November of 2020. The presentation was very well received, and at that time we did a limited number of contractual provisions and kind of went through the rationale and considerations and provided practical guidance on how to look at the provisions and how to draft provisions that would reduce the risk of a dispute. Alan had the brilliant idea of expanding the project and getting a task force involved, and we had overwhelming response in terms of interest in participating in the project. And if you go to the next slide, you'll see that we had 30 people, in-house lawyers, outside counsel, and neutrals participated in this project over a period of 18 months. So this was not a project where people just wrote chapters and the chapters were done in a vacuum. We actually met periodically every 2 weeks over the 18-month period and discussed the work product that was done by groups of lawyers. And the groups were structured in a way that we had input on each team from an in-house lawyer, outside counsel, and it was a mixture of both litigators and transactional attorneys. And so the work product that you have on your tables is really decades, probably centuries worth of experience from folks who really work in this space and have done this for many, many years. And so it is unique in that it wasn't a project where we had chapters and no one looked at the chapters. We all gave input. We had 2-hour sessions where people would present on their work product and get feedback, and revisions were made to the chapters to reflect that feedback. And so what you have here is, I think, a very unique project and a unique product that we hope will be a very practical guide. And again, this was really, David put a lot of work into this, particularly in the editing in the end, and it's such a shame that he could not be with us this morning.
Yeah, I think you can see from Armas to Zimmerman, we covered the waterfront. And really, for those of you that don't have access to this at the moment, here are the topics that are covered, just a few, within this very concise and well-bound book. So really looking forward to having you outside of this panel, sitting down and perusing the work product that is this manual. I don't know if we think about the value and how it can be utilized as a resource. Art, maybe you can speak to a little bit about who you think this manual is designed for.
Sure. I think the manual is designed for certainly attorneys who are negotiating and drafting contracts. Could be used by the business folks who are the clients, so they can understand some of the issues. And it doesn't matter what side of the transaction you are on. In the manual, we address both perspectives of a licensee and a licensor and what you might want to think about in each of those. The other thing I want to point out is, while this manual is purportedly about mitigating risk in life sciences transactions, it really does have a broader applicability. The focus was on life sciences transactions, but I think many of the issues here really are applicable well beyond that.
Excellent. Yeah, no, for sure. I think as a corporate lawyer who does a lot of M&A, this is a product that rings true to me in my daily practice, and is something that I look forward to utilizing on a regular basis. I don't know, Connie, if you want to talk a little bit more about why you consider the manual to be a valuable resource?
Sure. So, look, I think there are other publications out there that give you boilerplate language to use in contracts. This is much more than that. For each provision, we talk about what is the purpose of the provision. And then I think what's really valuable is the consideration section. And it does take it from both perspectives, from the perspective of the licensor and the licensee. And it really gives users things to think about. It's not spoon-feeding information. It really is going to require you to think about your transaction and what it is you can do to mitigate the risk. How can you bring clarity to the agreement so that you can avoid disputes in the future? And I think it is very valuable in that way. And I have actually, we got the final copies of the manual late last week, and on Monday morning I received a question from one of my colleagues, an attorney, who is working on a very complicated transaction involving multiple parties, and had some questions about, first, arbitration versus litigation, but more importantly, he wanted to make sure that the transaction was structured in a way to mitigate the risk of future disputes, given the many parties involved. And so I immediately said to him, well, I have something for you. We just published this manual, and I have a PDF of it, and I'm gonna, I pulled it up on my computer as we were talking, and I said to him, these are some things that you want to consider, and we're going to talk about some of this later, so I'm not going to go into a lot of detail. But there are things in the manual, particularly with regard to dispute resolution, that I think are new and innovative and are things that people who are drafting agreements should be thinking about. The use of neutrals and the like, in terms of how do you prepare a structure that in the event that there is a dispute, how do you resolve that dispute expediently? How do you get past that dispute and get on with the work that the parties want to accomplish? And so I think it is a really practical tool, and I think it's one that I hope most of you in this room will take advantage of. There is at least one copy on most tables, so please take a look. And there are also, on your table, there are QX cards where you can link to the electronic version as well.
Yeah, for sure. And so we're going to try to do what is, I think, somewhat of a difficult task and engage you in a discussion about a manual you have yet to read and that we prepared, right? So we're going to try to attempt to virtually eliminate the first row of tables that nobody wants to sit at, draw you all in a little closer to us and talk about the manual in a practical way through what? Through a hypothetical. And so we talked at length about how could we demonstrate the value of the manual without boring you to tears. And so really it came down to this. We thought about the Allen Waxman anti-aging cream and doing a role play really around this revolutionary new product. And as you can see, we've got demonstrated proof of the effects of this revolutionary new product. And so let me set the scene for you here just a bit. We have as our licensor Waxman Inc., which is a startup venture. They've developed, after years and millions of dollars of research and development, the Allen Waxman Anti-Aging Cream, which is a revolutionary new product that relieves the stress of disputes and provides years of productive and healthy business relationships. It's not your ordinary anti-aging cream. It's not what you think. It doesn't remove wrinkles. It helps you avoid disputes. It helps you manage your business relationships so that you can achieve the true potential. Not your ordinary everyday cream. Waxman has gotten FDA approval for their product, and they're confident that Waxman and AWAX, as we affectionately refer to it, will set a new standard within the complementary and alternative medicine products industry, or what we refer to and will refer to on a go-forward basis as the CAM products industry. Waxman needs to find a partner, of course, that will manufacture, market, and distribute AWAX as a premier and revolutionary new product. The future of Waxman Inc. depends on it, okay? And so with that, we talk a little bit about our licensee. Our licensee here, and I'll skip past this next one, right to our licensee. Our licensee here is Looks Good Therapeutics. Looks Good is a leading provider and producer of a wide range of CAM products with a well-established national and international distribution network. They're an ideal partner for Waxman Inc. LGD has its own line of anti-aging CAM products, including supplements, vitamin regimens, and hair care products, which I could use. LGT is excited about AWAX and believes it could not only become a sensational new product, but also bolster interest in LGT's own existing anti-aging products. And so we thought that the negotiation should happen, and Waxman and Looks Good have decided to meet and discuss the potential arrangement for the manufacturing, marketing, and distribution of AWAX. And in light of the urgency of the current situation, they've decided that the best place for them to meet and begin these negotiations would be on stage during the Life Sciences Licensing Transaction panel discussion here at the CPR annual meeting in New Orleans. And they have two critical issues they need to address. The first is LGT's use of commercially reasonable efforts to produce, market, and distribute AWAX. And the second is the potential use of revolutionary new dispute prevention protocols. And so with that, I'll turn it over to our representatives, Connie, who is CEO of Waxman Inc., and David Colvin, I'm sorry, David, not here. Art is our Chief Product Officer of LGT, and I will be representing Art and LGT as outside counsel. David would have been representing Connie as outside counsel, but Connie's going to do double duty here and really go 2-on-1 here. But that just goes to show the unlimited resources of LGT. You know, really, we've got probably a team of 12 lawyers on our side of the table, where Connie, you're just flying solo. So with that, why don't we turn to the use of commercially reasonable efforts, and maybe you can talk to us about your views on how that should happen.
Sure. So this is AWACS is an extremely important product for Waxman Inc. We're a small company, and a lot is riding on this product for us. And so we need to saturate the market. We need to make sure that this product is everywhere. We want to make sure that production starts right away, that this is your #1 top priority. We know you have a lot of other CAM products out there, but this has to be the first priority. We need to fully utilize your distribution system. This has to be the flagship product of your CAM product list. This can't be something that you don't put a lot of effort into. This has to be your priority as it is ours. So we want AWACS in every Sephora, every Ulta, every Blue Mercury store. We want end cap position. We want this to be in a superior marketing position in all of these retail outlets. And we need your agreement to do that.
Is there anything else?
Yeah.
That's it?
And, our expectation is that you're going to be acting in accordance of a top 5 supplier in this space. That's what we're looking for.
Wow.
Well, that's a lot to ask for. Look, we've got a lot of experience in this space. We know how to market products. It takes time. We can't immediately get a product out there and have it be the #1 product in the market and get all these things. We need to build it, just like we have built our other products. We've got tremendous advantage by working with us, because we can get in the door by putting the AWACS product together with our line of other products. That helps us get into the door to all these retailers. That's a key consideration to even being able to sell this product in the first place.
I don't want my product, AWACS, to get lost in the sea of your products. How are you going to ensure this? We came to you because we know you have the experience, but we came to you because you have the experience, you have the manufacturing capability. I need some assurances here that we are your #1 priority.
Well, we can assure you that we will be diligent in marketing, producing and marketing this product. Don't worry about that. We will use our commercially reasonable efforts. We'll consider all the various factors that need to go into that. How valuable this product is
I'm not a lawyer
for that.
here. My lawyer had a conflict this morning, and we're a small shop. So I don't know what that means. What does that mean to me? Commercially reasonable efforts, I have specific demands.
It means we're going to treat it like we treat other products that are of the same value as this product. So, if we have another product that is very similar to this product, it gets NCAP service, this one will get NCAP service. We can't guarantee you that you will get NCAP in every store. That's something we need to negotiate with the retailers.
But this is not like your other products. This product is far superior. This is groundbreaking.
Look at the results, really.
Yeah,
I'm sorry, I'm really helping her, which I probably shouldn't be doing. We can talk about that later. Give you a discount off my fees or something. I don't know. Well, look, maybe if we could utilize something that might work between us. I hear, Connie, what you're saying is you need some assurance. You need to know exactly what LGT is going to do to make sure the full potential of your revolutionary new product is going to do, that it achieves its potential. As Art, I think, has expressed, while we're really excited about this product and what it might do, we also can't, be in a situation where we are fighting back and forth about the efforts we utilized if what we all believe doesn't come to pass for reasons that may be outside of our control. We want to make sure that we work together collaboratively and in a way that, we understand what efforts we're going to put forward. You're comfortable with those efforts. What if we were able to utilize maybe in some areas more specificity rather than just relying on something as broad or vague as commercially reasonable efforts?
So what are you suggesting?
Well, I'm going to look to my client here for specifics, but maybe art, as we've done for some other products we've licensed in the past, maybe we could roll this out in regions in a specified manner. Maybe we could utilize and commit to utilizing a particular number of FTEs that would work on this product. I think the more specific we can be, and kind of your understanding of what those efforts will do, we can't guarantee the result, but we can guarantee or commit to maybe what resources we would dedicate to help market and promote your product.
Right. And we can get you comfortable by discussing our marketing plan with you in a little more detail. So you have an idea of what we intend to do. We need to maintain some flexibility within that plan because we need to be able to react to whatever the situation is at the time.
And how often are you going to share this marketing plan with me? I mean, you're not going to have one marketing plan for this product. Is it going to evolve over time?
It evolves. We adapt those, over time, typically annually, sometimes a little more often, depending on the circumstances. But we can meet, maybe schedule regular meetings with you on a regular cadence so that we can give you an update on what we're doing and hopefully make you comfortable with how we're proceeding with your product.
I think what we want to try to do ultimately here, Connie, is remove ambiguity from the contract to the extent we can. And I think that's beneficial for both parties so as to mitigate potential disputes down the road. If you know what LGT is going to do and commit to, and we understand what those obligations are, I think we're better able to perform in a way that is consistent with each party's understandings and expectations. I think you recognize and understand that we can't guarantee the results. We all are, really supportive of AWACS, but we don't know ultimately whether the market will accept it or not.
That sounds reasonable. Why don't we put a pin in this and move on to some of the other provisions in the contract?
Yeah, I appreciate that. I think one of the things that's really critical to us, kind of in the context of revolutionary new products and the removal of stress and anxiety from potential disputes, is the utilization of a relationship facilitator and the CPR model dispute prevention provisions in our arrangement, and we'd like to make sure that we memorialize that in our contract.
So I took a look at what you are proposing, and I have to say, no way. That sounds really expensive, bringing in outside facilitator. I mean, you're anticipating we're going to have disputes. That's going to cost us a lot of money. We're a small company. We don't have the resources for this. You're going to have to do a lot of selling to me to explain to me why I would want to invest in this, because to me it sounds like a bad idea and not in our best interest. It just seems like you're planning for the worst rather than going into this with, with the right mindset.
Yeah, no, I think that's a fair point. I guess I just ask you to re-examine the spirit in which we're bringing this to the table. I know that there's been large acceptance over the years about alternative dispute resolution procedures. But what we're talking about here is something new, something focused on dispute prevention. And Connie, let's just start with some basic common principles that I think we can agree on. Are you interested in the context of the production and distribution of AWACS and trying to avoid disputes with my client?
Yeah, obviously, we don't want to have any disputes, but what you're proposing seems very complicated, and it seems like it's really expensive, and we just don't have the resources.
Yeah, I don't think it needs to be expensive. We can talk about the specifics of it, and we can tailor these provisions in a way that can manage costs in a way that is beneficial to both parties. But you have to keep in mind the end goal, which is to prevent disputes. And if you're successful at presenting even one dispute among our two parties here, it'll be worth it.
It'll pay for itself in that circumstance. It's also, you may want to look at it not so much as a dispute issue, because this really isn't about dealing with disputes once they happen. It's about getting a healthy relationship and having someone help both parties to do that, to communicate well with each other, to identify any issues before they become problems, and help both of us have a very successful relationship.
So this person, this facilitator, how does that work, and what kind of person is qualified to be a facilitator?
Yeah, we would mutually agree on the identity of that person. It should be somebody who has industry experience, obviously with products similar to AWACS and the CAM products that LGT distributes. So we can talk about who that person should be. I'm happy to report that CPR is in the process of developing training for these individuals, and there are many well-qualified mediators and arbitrators in the CPR suite who bring skills that are going to be applicable to this type of role and arrangement. And so if we just take a look at the existing landscape there, we may be able to collectively identify somebody who has experience in our industry and can really serve and add value to our relationship. But the key here is independence. The key is somebody that we both respect and trust, who can help us navigate our relationship on a go-forward basis.
Has LGT used one of these facilitators before?
This is brand new for us too, and we are focused on trying to implement this in our arrangements going forward. So the answer is no.
Right. What we have used is alliance management with internal people, but this is new, bringing someone from the outside in to help that. So it's a new flavor of alliance management, but we think it would be much more effective to have someone external do it that both parties can trust and really isn't taking the side of either party.
And how do we educate that person about our deal and what's going on here?
Yeah, I think it's critical that we bring this person in at the outset, right? There are different ways in which you can implement this regime. You could have somebody on standby who only comes into play when there's difficulty or a disagreement between the parties. Here, what we're proposing is to engage a relationship facilitator from the outset of the agreement so that they understand the history of the relationship, how the relationship will play out over time, rather than just parachuting in at the time a disagreement might need some outside attention. We think it's critical to set the tone and put these provisions in our contract so that this survives, us. We as executives of our respective clients may not be here a few years down the road, but if we memorialize this arrangement today, when things are at the outset, when we're in our honeymoon period, in our arrangement, we really set the tone for those that follow us. And if we do this right, I think we can really demonstrate a pattern of behavior that will be a model for those that follow us, because we really believe that this will be a long-term successful partnership.
Now, you mentioned a pledge before. What was that all about?
Yeah, so the pledge in the provisions are a non-binding pledge where we agree that we are committed to dispute prevention and that we will regularly communicate and engage in good faith dialogue with each other with the goal of dispute prevention and recognizing the economic and business value of our relationship. And so it's really just putting into words in a contract our commitment to this concept.
And how common are these pledges? You know, this is our first deal, so, you know, we're new and we're novices, but is this something that's commonly in contracts of this nature?
At this point, it's not, but that we're hoping that that will change. And change starts right here with us. And if you want to see those who are committed to this concept, there is on the CPR website a list of companies that have taken a pledge and signed up to the Dispute Prevention Pledge. And so it's not just us. There are many within the industry that are committed towards this type of concept and implementing this in a way that's meaningful and that will result in more widespread adoption of this approach. So, you know, I think we're laser focused on making sure that we benefit and improve our strategic partnerships, and we really feel like this could be a really good way. And Connie, if you're having concerns about how we might implement this or whether it'll be effective or whether it'll be too costly, you know, I guess maybe a suggestion for us to try to move this forward would be to implement this on a temporary basis. Maybe we could agree that we will try utilizing this provision for, call it 2 or 3 years, and have it limited in scope and nature, that we would only meet maybe on a quarterly basis or biannually at the outset with this third-party relationship facilitator, so as a way to manage our costs. And then if after that 3-year period we decide that, you know, we want to move in a different direction, then, or if we want to extend and continue on, we recognize the value, we could do that at that time. Would that be something that you think might be worth trying?
It's definitely worth considering. I'll have to bring it back to my team and we'll discuss it.
Great.
Excellent. All right, so with that, we would like some engagement because we've talked at past annual meetings about these provisions. We have at a training session in November in New York, some people in this room participated in that training. And you know, one of the things that I think we get a lot of is, come on, you know, you can't really be serious, right? So give us your thoughts on this. Is this, yeah, go ahead.
I'll start talking.
Sure, yeah, absolutely.
Hear me. You know, there was that interesting exchange that Peter and Connie had where Connie said, this hasn't been done before. He seemed a little skeptical. I mean, this has been done a lot in the construction industry.
Sure, DRBs all the time, yeah.
I've heard consistently that it's done with remarkable results. You know, you have these 10-year billion-dollar projects without any disputes, and the dispute resolution, it's typically a board rather than a single facilitator. And they meet quarterly, and somehow they keep the project ongoing with very, very few disputes. And I wonder if it would be, granted they're very different industries, but I wonder if it would be worth, you know, bringing anecdotes or people who can talk about the dispute board in the context of construction to the life science industry and explain what the analogies are and why it works so well when you have a long-term project between 2 or more people who have to collaborate with each other over the long term.
Sure, I think that's a great point. We've talked about, Alan and I have talked about the potential of having testimonials on the website for people who can talk about that. There, in particular, a gentleman by the name of Howard Karsman at Intel has been really helpful to the development of those dispute prevention provisions, and he's talked about just what you're speaking about, you know, the utilization of that within an organization. Now, that, as I understand it, those were in the context of constructing large facilities that took, you know, billions of dollars over years, but that they were really successful in avoiding disputes with their contractors and subcontractors. Sure.
This is Neera Merchant from India. Whilst you were communicating with Connie, you mentioned this pledge provision is a non-binding provision. So then, I mean, if it's not binding, and if out of, when a dispute arises, say one party is not just willing to kind of invoke the pledge provision and just want to take the other party to the court or to an arbitration,
Yeah.
then does it even make sense to have this pledge provision in the first place?
Yeah, and maybe we glossed over it a little too quickly in our hypothetical. The provision itself begins with a non-binding pledge where we, as contracting parties, commit to a dispute prevention regiment or protocol. It is followed by binding provisions under which we would agree how the relationship facilitator is selected, that we would agree to meet with that relationship facilitator on a quarterly basis. And it goes in, and again, you can go with the full-on model provisions if you want, or you can narrowly tailor them. But they include things like, in connection with your quarterly meetings, each party preparing a progress report. And that when you're at those meetings, not only do you share your progress report with the other party, but you make a presentation at that quarterly meeting about your performance, how you're doing in meeting your KPIs or in performing your contractual obligations. And you have an opportunity then to share with your counterparty and with the facilitator areas where you think there might be potential headwinds or complications on a go-forward basis. So there are both binding and non-binding provisions. And I will just quickly note that I've tried on multiple occasions to try to get these provisions introduced into joint ventures that I've negotiated or other long-term supply arrangements. And so far, I've had mixed success. But one of the things that I haven't had any problems doing is getting that non-binding pledge in. It's like trying to get people to agree that the sky is blue. Are you committed to preventing disputes? Of course they are, right? And so can we at least memorialize that in the contract in a non-binding way so as to orient the people who will be executing on this contract that we're serious about this, that we really want to try to avoid disputes. And so that's something I've been able to do in my recent negotiations. I don't know, Ellen? Somebody.
You covered it. I was going to say the non-binding aspect of the pledge is you're not saying I will never bring an arbitration or litigation if down the road we just get to that point. What the pledge is a current intention to represent, I care about the relationship, and I'm willing to say I will pledge to do what I can, implement mechanisms that will hopefully prevent a dispute and the ruination of this relationship. That's what the pledge is.
Yeah.
Yeah, no, I know, but I just...
Yeah, it's hard to get the full flavor just through a negotiation, but...
On a lighter note, never have a non-binding clause with an Indian counterparty.
Okay. The advice was never have a non-binding provision with an Indian counterparty.
Other comments?
There's another comment in the back.
The concern that I heard in the mock negotiation that you just had, and I think is very real, is this is a cost. Why do I have to spend this extra money? And I think the trick in selling this, and I shouldn't use the word trick, that what needs to occur in selling this is to present it as saving money. AWACS started out with, they're really excited about this project, and they were demonstrating excitement. The manufacturer, in order to demonstrate we're equally excited about this, we're going to commit some of our resources to make sure that this goes really well. In other words, you've got to turn this into a cost-saving process as opposed to a negative. And that's in how you present it. And then you give the anecdotal and the empirical evidence of how it works.
Right. Yeah, I think those are great points.
And we have another comment up here.
The relationship facilitator is a great idea, but just as you're hearing in the construction industry, we use these arbitration panels that are on standby because it can cost hundreds of millions of dollars if there's a stoppage over a dispute. So one, the value proposition has already been made, and that's what needs to be done here, and that's what you're hearing. Make the value proposition. But the best value proposition is being able to show where it has worked.
Yeah.
And the way to do it with these new programs we discovered is by having a pilot program somewhere. Pfizer, for example, initiating a pilot program.
Sure.
And then you're referencing that and with these testimony, but this is an innovation that we have to find a way to move forward, because particularly in the space of dispute prevention, this is where the action is, and no one else is doing this in the ADR space. My compliments and a great panel. Thank you for putting it on,
Sure.
Brian.
I was at the corporate roundtable yesterday and noted the representative from General Motors speaking about this concept and wanting to implement that and some of their arrangements going forward. And so this is, it's rooms like this where this type of concept takes hold and takes root, and we're hopeful that, going through this process of back and forth and Q&A can help us refine our message, do a better job at demonstrating the value proposition, and then, trying to get more and more people to take a whack at it and look at those other examples that have been successful, like DRBs in the construction industry, as a path forward. Because, the goal is that when we come back 5 years from now, 10 years from now, the mere explanation of what a dispute prevention provision is why take the time to do it? It's so readily utilized and well developed. So that's where we're hoping we're going.
I'm sorry to jump in again. I was
Yeah.
talking to Ellen and asking whether there have been any studies or estimates of what the costs are. I would think having a single person doing this for a few hours on a quarterly basis would be really pretty minimal.
Right.
And could save an awful lot of money.
Yeah, for sure. In fact, we are currently working on a model engagement letter for a relationship facilitator, because that was in the training session that we did back in November. That was a real focus of some of the participants questioning, well, how does this work? What is my role as a relationship facilitator? What does this look like? And so we've been trying to put some definition around that role, what fees would look like, and all the rest that goes with it. How do you address things like confidentiality among the parties? It's easy when you think about confidentiality of those quarterly meetings vis-a-vis the rest of the world, right? Of course, it's like a mediation. It's gonna remain confidential. But if Art is my relationship facilitator and Connie and I are in a contractual relationship with each other, and I meet with Art on a one-on-one basis and tell him those areas that I'm really worried about because, I don't know, my CEO is been diagnosed with cancer, and I don't know about the future of my company right now, but I can't tell Connie that. I don't want to tell Connie that because I don't want to create concern, or whatever my business issues are that I want to tell Art, but I don't want to tell Connie, at least right now. How do you deal with that? What are Art's duties in terms of respecting the confidentiality of that communication, even if Art believes that he can utilize that information in a way that might be beneficial to the relationship, in a way that prevents a dispute from coming down the road. So, yeah.
Just a footnote on costs.
Yep.
The parties are typically more concerned about their own costs to participate in the process. So, yes, you can make a presentation about the costs of the process as we bill you are minimal, but that's really not the most significant part of their thinking. They're thinking about what will it take away from my day, from my planning, from my department, for staffing the process. So factor that in also.
Yeah, I think that's a really good point, because I know the business people that I deal with, the last thing they want to deal with is another meeting. And I've had some disputes recently where I've made the suggestion that maybe we go to mediation or we go to an arbitration instead of litigating a dispute. And the business people, their response is, how much time is that going to take for me? How much of my day is this going to take? So I think that's going to be part of your resistance. Candidly, I have seen these provisions suggested by smaller parties more recently, and when it has come to me, I have said, I think it's a good idea. So, because I do think if I was a smaller company, it probably is a good investment in terms of preventing disputes, because arbitration can get very costly as well. And so I think it's something that people should be giving greater consideration to. And I think we do need to get the word out there and to really kind of tout how this could really be a tactic to, to reduce, the amount of disputes, and to do it in a very expeditious way.
Right. The other point, just to add on to what Connie said, is, aside from like the financial costs of arbitration, it's going to cost those people a lot more of their time.
Yeah.
If they do get into a full-blown dispute, whereas they can invest a little bit of time now and avoid that more extensive use of their time later. Additionally, you may be able to even further minimize the time by leveraging some meetings that already exist. Oftentimes, in these collaborations, there's quarterly, semi-annual, or annual meetings between the parties anyway. You could have the facilitator attend those meetings so they can be abreast of what's going on without really using any extra time of the parties, or very little extra time of the parties.
Can I ask a question? And Art addressed it a little bit. Connie, do you think your business people who would say, oh, how much time will this cost me? Do you think their response would be different if they had already experienced an arbitration or
Yes.
litigation?
Yes. And I work with some people who have actually gone through arbitration with me now, and I think they would be more receptive to it. I think the other people who we need to win over in terms of these concepts is some of the business lawyers. I mean, I have some business lawyers that I regularly deal with internally who still think litigation is the best leverage we have. And I'm not so sure that that's really the case, but there are certainly people that I've tried to say when an agreement comes in with an arbitration provision that they should consider it and really give it some thought, not just say out of hand no because you think litigation is the ultimate leverage.
Just a hint, you may carefully structure it if a party does not refuse to use a facilitator and goes directly to arbitration, that the award later on will be enforceable, because some courts treat an obligation to use a facilitator or to have an prior to arbitration, some settlement discussion in good faith. Mm-hmm. If this is not adhered to, that it is a breach of public policy.
Okay. I will note that in our draft model provisions, we do provide that, this concept of dispute prevention is really centered around communication, regular interaction and open and honest communication between the parties. And then the provisions go on that, look, as we readily acknowledge, there's no contractual provision you can write that's going to avoid or prevent all disputes. So it acknowledges that when a dispute arises, there's what I would describe as a kind of traditional escalation clause with some twists, right? So there's the potential for your relationship facilitator to serve if the parties so choose and the mediator or the relationship facilitator is willing to then act as a mediator between the parties. And that relationship facilitator, again, if the parties are interested and if the relationship facilitator is willing, that person would issue a report. If they're unable to settle their differences, issue a report with the relationship facilitator's recommendations and findings. Non-binding, but hopefully would give some direction to the parties as to where he or she thinks this dispute is headed if they continue to advance and continue to escalate up the chain. But it starts with kind of your traditional, the everyday executives who have day-to-day responsibility of the relationship. Meet and confer to try to see if they can resolve. If they're unable, then you escalate to senior C-suite level executives in an organization. If that's not successful, then you go to mediation and eventually to arbitration. But we have included in the model provisions express agreement by the parties that you can bypass one or any or all of the stops along the way. Because one of the things we also expect parties to say is, not only is this too costly, but it's too slow. I can't get the relief that I need. And so we've tried to anticipate that, the need to either truncate or bypass certain provisions along the way. But to your point about public policy and the potential violation of that, at least in the States, we thought about, well, what can we do to incentivize people not to, pull the ripcord and, do not pass go and all the rest. And so we included a provision that said, in the event that a party elects to do that and truncate or bypass a provision, that in the event that a dispute ultimately goes to an arbitration, it gives the power to the arbitrator or the arbitration panel to award fees to the other party or to the party that did not, truncate or short circuit the dispute resolution process. We were trying to give some teeth to the notion that the parties would abide by what we really see as a valuable process in avoiding disputes. So, yeah.
Alan?
First of all, great panel. I didn't realize you were going to do compassionate use. So thank you for bringing.
It's all him, just so you know.
Recently, we negotiated a contract at CPR. Now, it was a little easier for us to insist on putting in dispute prevention provisions because I told our counterparty I couldn't show up not having put these provisions in. One of the things that was helpful was just going through the exercise of identifying a neutral. So just having a conversation, what kinds of disputes might arise, what kind of person might we need to have in place as a neutral to help us bridge gaps and so forth, was just in and of itself a useful piece of the discussion that we had. We've never had to rely upon the third party.
Sure.
I'm wondering kind of the recent experiences you went through with these small parties. Can you say more about what the experience was like in just talking through it, or did you identify a neutral, or?
Yeah, I can say a little bit. So the first thing I did was, as you said, I spoke to the person who was negotiating the contract, and I said, so I need you to think about this deal. What are the likely disputes? And are they the kinds of things that are going to really hold up progress in terms of the project? Do you, what do you envision? And I think a lot of times when I like to do this when we're actually doing drafting and when people come to me with dispute resolution clauses or a question about jurisdiction or arbitration versus litigation, the first thing I say is, what are the likely disputes here? Have you given them any thought? And sometimes people have, and sometimes, particularly with newer people, they're like, I really hadn't thought about that. Because no one is really focused on that. And on the smaller deals, I think oftentimes they do. I think on bigger deals, and in all candor, in bigger deals, dispute resolution and these provisions are not a priority. And I think, these are the areas where if there are compromises to be made, they are made in these areas. But on smaller deals, I think people are often more open to trying these kinds of things. And I think particularly now, I think given the economy and things that are going on, I think everyone is a lot more cost conscious than they were previously. And my view is, I think it can be a real cost savings. And I do think, again, I think it is also that manpower savings. I do think time, at least in my industry, I think is our greatest resource. There's not enough hours in the day. We're working much quicker than we ever had before, and I don't think that's unique to my company. I think that as an industry, the pandemic has changed the way we approach things, and I think in a lot of ways it's good for society because we are working harder and faster to bring treatments to patients. And so implementing the facilitators, I think, can help that process. And I think, to me, having gone through several arbitrations over the last 3 years, we often have the same counterparty in multiple transactions in the business. If you have an arbitration going on, it affects the relationship, and it's not only as to that transaction, it makes it difficult elsewhere. And just given the way in which the frequency with which we have the same partner in multiple aspects of our business, I think broader consideration of these facilitators is something that I'm certainly going to bring to the table, because I do think it allows us that efficiency, get past this dispute, you have somebody in place, and then you're not bogged down with the threat of litigation or arbitration, et cetera.
Thank you. I talked on day one about a survey we're doing with the University of Tennessee's Haslam College of Business, collecting these kinds of experiences. So please, there are cards and ways you can access the survey. I think it's so important we start developing a database of experiences here, the testimonials Peter's talked about, experiences, Connie, you've had, because I think everybody wants to know when they hear about this, does it work? What has your experience been with it? So the more we can do in collecting these, so all of you, if you have the opportunity, please take the survey, share it with others. It's just helpful information.
We got a couple of minutes left on our clock, but unless others have additional questions, thank you for your time and attention and your participation.